Hello. Hi, AV. I wasn't quite ready, but since you were tapping your foot, I thought I'd go ahead and get started. How are you guys tonight? I see there's people here watching, AV and Jessica. Let me know if you can hear me first, because I could totally be muted and not even know it. Yeah, tell me if you can hear me first before I start saying stuff and then have to unsay it again. You can. Okay, perfect. Okay, I have a couple of things tonight. The first thing I wanted to show you is something from one of my favorite judges, who is Judge Weaver. I showed a video from this court, not the same court, but same town, different judge from Judge Hand. I think either last time or the time before. And what I know about it is that it's a really small town. So people definitely know each other. And he's just super charismatic, and seems like he would be a lot of fun to talk to. And this is Texas, a very small town in Texas. I believe it's Potter County. I should totally look that up and show you guys where it's at. But anyway, this is a very underappreciated judge. And by underappreciated, I just mean I don't see him around on YouTube a lot. But then again, maybe I'm just not looking in the right places. So I'm going to share this screen. Oh, wait, hold on. Sorry, guys. I think no matter how many or how much I get ready, I'm never going to be able to be totally prepared. Hold on. Where'd it go? What's it called? What did I call it? I'm sorry, guys. Okay, I got it. Here we go. Oh, wait, yeah, this is Texas. Oh, you're talking about my blue shirt? Yeah, I was planning on just wearing my lucky sleeping sweater every time that I streamed. That way I didn't have to worry about thinking about clothes or what I needed to wear. But one thing I didn't take into consideration is that I love that sweater and it's very special to me, and I have to make sure that I wash it, and then it has to lay flat to dry. There's no dryer because I just need it to last forever. So yeah, it's drying and I can't wear it, which makes me sad, but I'll survive. Okay, here we go. Judge Weaver, Potter County. Let me know if you can hear
it. Collie. And then we're going to throw it back to Mr. Wilson to see if Jeff Hill can cut in line since he was here.
Sorry.
Who else is here? Oh, Collie.
We good?
State of Texas versus Tommy Theisen.
Thank you, Jessica.
Collie.
And thank you guys for being super patient.
Throw it back to Mr. Wilson to see if Jeff Hill can cut in line since he was here.
Thanks.
All right. Tommy Joe Theisen, are you here?
Yes.
Mr. Theisen, did you hear me when I introduced myself? Hang on. We got some feedback somewhere. All right. Mr. Theisen, did you hear me when I introduced myself earlier?
You say Collins or Collins? Mr. Collins?
Nope. Hang on, something's happening.
I can't hear him, Judge.
Okay, scoot your left, Mr. Theisen. All the way left. There we go. Good afternoon, Mr. Theisen. Can you hear me?
Yes.
Better?
Yep.
Better, we're getting feedback somewhere. Mr. Colley, got noise in your room or something?
No, Your Honor, I don't think so.
All right, well, let's pay attention to the court reporter. If she's having difficulties, let's all stop talking and let her solve it. Mr. Theisen, my name is Walt Weaver. I'm the judge of Potter County Court of Law number 1. I've been assigned the duty today to hear your case. I've reviewed the materials. It appears to me you're going to waive your rights.
Yes.
However, you have a constitutional right to appear in my open court and face your accusers, or you could waive that right as well and agree to appear by video. Are you agreeing to appear by video?
Yes.
Okay. Court now calls for trial, cause number CCCR-23-69-1, the state of Texas versus Tommy Joe Theisen. What says the state?
State's ready, Your Honor.
Thank you, Mr. Davis. What says the defense?
Defense is ready, Your Honor.
I cannot hear you and I don't know you. Would you please state your name for the record and get a little closer to the microphone?
Yes, Your Honor. Can you hear me now?
Perfect.
Okay. My name is Ethan Colley. I work at the Manager Assigned Counsel's office.
Excellent, Mr. Colley. It's a pleasure meeting you. Are you ready for trial?
Yes, Your Honor.
Thank you, Mr. Colley. Mr. Theisen, did you hear your attorney's announcement?
Yes, I did.
He announced ready for trial. Were you aware that today is your trial for the Class B misdemeanor accusation of criminal trespass?
Yes.
Do you read, write, and speak the English language?
Yes, I do.
Have you in the past, or are you presently being treated for any kind of psychiatric condition?
No.
Are you a U.S. citizen?
Yes.
Tommy Joe Theisen, how do you plead, guilty or not guilty, to Class B misdemeanor accusation of criminal trespass?
Guilty.
Thank you, Ms. Theisen. Before I accept that plea, however, I need to make an inquiry in the record as to your understanding of today's proceedings. Before me, I have the negotiated plea bargain agreement. It is attached to a plea memorandum with your signature on it. Do you recall signing the plea memorandum with the assistance of your attorney prior to today's trial?
Yes.
What's so funny, Mr. Theisen? Are you okay?
Yes.
Okay. You okay to go forward?
Yes.
How much you know, all morning, no one laughed at any of my jokes, so
Okay.
maybe they're just now hitting the atmosphere.
Yeah.
Well, did you plead guilty?
Okay, sorry. No, you didn't miss a joke. All right, see you in a few, AV. Okay, I think there's a name for it, but I can't think of what the name actually is. But when you laugh at inappropriate times, like maybe when you're uncomfortable or when you're really nervous, maybe, and I think that's what this guy might have, but that's one of the things I really like about Judge Weaver is that he kind of goes out of his way to like gloss it over, to kind of like bring it up without like making fun of him or, I don't know. I just feel like he's trying to make him a little bit more comfortable and like that it's okay and it's okay for him to relax. So let's go.
Guilty or not guilty?
Guilty.
All right, before I accept that plea, I do need to make an inquiry. Do you recall signing the plea memorandum with the assistance of your attorney?
Yes, I do.
Any questions about this document you may have had that your attorney could not answer?
I think the only thing is there's a $310 court fee. I don't know if that's going to be covered with the 3-for-1 or the court times or the jail time served.
You know, I will address that issue when I get to it. And if I don't answer that question to your satisfaction, you can withdraw your plea and we can start over. Do you understand?
Okay.
All right, then. Other than that, any other questions?
No.
Your signature tells me that you know you have constitutional rights that you do not want to use in exchange for the plea bargain agreement.
Okay, so what he's talking about is like the 3-for-1. You're awkward. Well, I mean, that's a good, I mean, laughing is not a bad way to cope with things. When he's talking about 3-for-1 or time served, what that kind of tells me is that this isn't his first time being in this spot where he is facing criminal charges. And based on the fact that it's like a really small town, everybody knows everybody, he's probably not a stranger to the judge. Okay. Play.
So, for example, do you know what a jury trial is?
Yeah, I believe so.
Okay, are you sure?
Yeah, it's when I think 12 people come to court, they get a letter in the mail and they have to show up. They get subpoenaed or something.
Yeah, and they listen to evidence, and they're the ones who decide if you're guilty, not you. You could say, I'm not guilty, and let them listen. Do you understand?
Yeah.
Do you want one of those jury trials?
No.
Okay. Mr. Theisen, I think you understand the rights that you're waiving as evidenced by your questions to me, your answers, your signature, and your attorney's signature assuring the court that you have at least talked about it. So I'm not going to read everything to you, but I would like to talk about two of the rights that you waived. You have a right to remain silent. You waived it by pleading guilty. You have a right not to give evidence against yourself. You waived that by signing a judicial confession. No one can make you do either one of those two things, Mr. Theisen. But if I believe it and accept it as evidence, that is enough evidence today at your trial to support a finding of guilt. So will you consent to my questioning? Let me place you under oath so I can talk to you about it.
Yeah. Yes.
All right, raise your right hand. Do you swear or affirm the testimony you shall give will be the truth?
Yes.
All right, put your hand down. Tell me, Joe Theisen, did you voluntarily plead guilty and did you voluntarily sign the judicial confession only because you are guilty and for no other reason?
Yes.
Are you satisfied thus far with Mr. Cawley's representation of you?
Yes.
Mr. Cawley, do you feel comfortable expressing an opinion, if you have one, as to your client's competence to stand trial?
Yes, Your Honor. We talked about his case and the matter today. I believe he's competent.
Thank you, Mr. Cawley. Mr. Davis, has the state complied with the Michael Morton Act and that you made available to the defense the evidence in your possession?
Completely, Your Honor.
Thank you, Mr. Davis. Mr. Cawley, are you satisfied the state's complied with the Michael Morton Act?
Yes, Your Honor.
And did you discuss the evidence that was turned over to you with your client?
Yes, Your Honor.
Thank you, Mr. Cawley. Mr. Theisen, today is your trial. The state accused you of a criminal act. They investigated it and they were done. They felt confident they could prove your guilt beyond a reasonable doubt. They then gave it all to your defense attorney. Did you have a conversation with your defense attorney about the evidence that the state of Texas wants to use against you today?
No, we never did.
Never talked on the phone?
Oh, yes, I did talk with a defense attorney over the phone.
Okay, it's not a PowerPoint, and it's not a movie. It's just a conversation about what the evidence would be. Were you here? What happened? Did that happen?
What's that?
A conversation with a lawyer about your accusation of criminal trespass.
No.
All right, well, we're going to set this aside. We're not going to do this today, and we'll reset it after you are afforded an opportunity to speak, Mr. Cawley. And if you'll wait there, after I'm done with everybody else, I can create a breakout room so you can talk confidentially with him and have the entire YouTube audience not watch it. So if you'll return to your cell.
Okay.
Thank you, sir.
Thank you.
Ms. Wilson, as custom would have it, you'd be next, but you have 1 million cases and Mr. Hill has one. So what do you want to do?
I'll defer to Mr. Hill in the circumstances.
Okay, let's
Wow,
go.
that's awful kind of you, Mr. Wilson. Mr. Hill, are you ready?
Judge, I am, and thank you, Mr. Wilson. And I apologize earlier, Judge. I was having a USB problem on my computer. It wouldn't pick up the microphone or the
no.
camera, so my apologies. I'm now on my
He
phone.
was not pleased. You could see that.
Sure.
Okay, now I
You
gotta
just owe
switch
Mr. Wilson a
over.
fruit basket.
No
Okay.
problem.
I gotta get the second video. I broke it in half so I
Would
can move it
Dickey,
faster.
Lynn, Hanley please approach again?
Open
You seem
this.
disappointed not to have seen you earlier.
Okay. Now, moving it.
Mr. Hanley, do you remember me?
It's gonna end in a second.
Can you scoot to your left? A little bit more.
Wow.
Yeah, that's it. The microphone's right by your elbow, so I need to be able to hear it.
There we
That's
go.
all right. Do you remember my introduction and your right to appear in person?
Yes,
Are you waiving that right and agreeing to appear by video?
yes.
All right. Court now calls for trial. Calls number CCCR-22, -1180-
Okay, this is where it gets a little messy and my transitions are not that smooth. So, okay, stop screen, share screen. This is not the one. This is the one. And fingers crossed. Yes, I was muted again, Jessica. Yeah, it's a struggle. All right, here we go. We should pick up where we left off, approximately.
Microphone or the camera, so my apologies. I'm now on my phone.
Sure. You just owe Mr. Wilson a fruit basket.
No
Okay.
problem.
Would Dickey, Lynn, Hanley please approach again? You seem disappointed not to have seen you earlier. Mr. Hanley, do you remember me? Can you scoot to your left? A little bit more. Yeah, that's it. The microphone's right by your elbow, so I need to be able to hear it. That's all right. Do you remember my introduction and your right to appear in person?
Yes,
Are you waiving that right and agreeing to appear by video?
yes.
All right. Court now calls for trial. Cause number CCCR-22, -1180-1. The state of Texas versus Dickey, Lynn, Hanley. What says the state?
State's present ready, Your Honor, for an anticipated plea of guilty. Additionally, if Mr. Hanley does plead guilty, we have agreed to dismiss cause number CCCR-22-1179-1.
All right. Thank you, Mr. Davis. What says the defense?
Ready, Judge. We'll waive the reading.
Thank you, Mr. Hill. Mr. Hanley, did you hear your attorney's announcement?
Yeah, yes. I
All
want
right.
to ask him a question if I could.
What is it about your case or the deal?
Yeah, I wanted to change my plea. I wanted to go to trial.
All right. You may return to your seat. Thank you very much.
All right, thank you.
I'll give you a call, Mr. Hanley.
You were this close, Mr. Hill. This close.
Thank y'all.
All right.
Thank you, Chuck.
Wow.
I'm glad you're here.
You owe him a fruit basket and you get no benefit. All right. Would Mr. Dirk Andrew Campbell please approach?
Your Honor, I believe that was the last of the misdemeanors. May I be excused?
Well, except for the guy who wants to, Mr. Theisen. So you can cover your mic up.
Yes,
Or you
Judge,
could-
she wants a breakout room.
I'm sure he does, but I gotta let Mr. Campbell go forward before we punish anyone else. All right, so you may want to call him on the phone, Mr. Davis, on your own, and see what's going on. Mr. Campbell, can you hear me?
Yes, sir.
Mr. Campbell, did you hear it earlier when I introduced myself and told everyone about their right to appear in my court?
Yes, sir. I did hear you.
All right, then. Well, are you going to agree to appear on video and waive your right to appear in my court?
Yes, sir.
All right, then. Thank you, Mr. Campbell. The court now calls for trial several cause numbers being the state of Texas versus Dirk Andrew Campbell and cause number 75606-B, 75879-B, 75890-B, 81318-B, sorry. 81319-B and 81502-B and 83145-B, all -CR. What says the state in each of the causes?
That's right, Your Honor.
Thank you, Mr. Baskett. What says the defense?
Judge, the defendant's ready for negotiated pleas of guilty in each of the cause numbers mentioned by the court, and we will waive the reading of the indictment in each of those cause numbers.
Thank you, Mr. Wilson. Mr. Campbell, did you hear your attorney's announcement?
Yes, sir.
And I'm going to call them all in the same order throughout this proceeding to avoid confusion. Your attorney announced ready today for your second-degree felony accusation of possession of controlled substance, penalty group 1, greater than or equal to 4 grams, but less than 200 grams with 1 felony announcement. One of them is a state jail felony possession of a controlled substance. A lot easier, except they're not in the same order.
And I apologize, Judge. That was sent to me by the DA's office, and that was the only thing I could quickly send to you.
It's all good. We're going to get through this. And then the next one I read, for the benefit of the court reporter, is another possession of a controlled substance, penalty group 1, less than gram state jail felony with
Glad you're here.
2 prior felony enhancements. And the previous one had 2 prior felony enhancements. The one cause number 318 is a first-degree felony manufacture delivery of a controlled substance greater than, or penalty group 1 greater than or equal to 4 grams, but less than 200 grams with a single enhancement paragraph. The next one in cause number 319 is another first-degree manufacture delivery of controlled substance, penalty group 1 greater than or equal to 4 grams, less than 200 with a felony enhancement. Another first-degree manufactured delivery of controlled substance, penalty group 1, greater than 4 grams but less than 200 with an enhancement paragraph. And finally, Mr. Campbell, and this one's a different name. This one actually says Dirk Andrew Campbell Sr. in cause number 83145-B-CR, which is a third-degree felony possession of a controlled substance, penalty group 1/1-B, greater than or equal to 1 gram but less than 4 grams with a single felony enhancement paragraph. Mr. Campbell, were you aware that each of these, today is your trial for all of these stated accusations?
Yes, sir.
Do you read, write, and speak the English language?
Yes, sir.
Have you in the past, or are you presently being treated for any kind of psychiatric condition?
No, sir.
Are you a United States citizen?
Yes, sir.
Dirk Andrew Campbell, also known as Dirk Andrew Campbell Sr., how do you plead to these stated causes? Guilty or not guilty?
Guilty, sir.
Thank you, Mr. Campbell. Before I accept the plea in any of the causes, I need to make an inquiry on the record as to your understanding of today's proceedings.
I do understand, sir.
Well, it's okay. I was
Oh,
lost
okay.
in thought as to how I was going to organize it. It wasn't you, it was me. Before me, I have the negotiated plea bargain agreements in each of these causes. They're attached to separate plea memorandums outlining your rights, and it also reflects allegedly your signature throughout the document. Do you recall signing all of the plea memorandums with the assistance of your attorney prior to today's trial?
Yes, sir.
Were there any questions about any of these documents that you may have had that your attorney, Mr. Wilson, could not answer?
No, sir, I have no questions.
Mr. Campbell, your signature tells me that you know you have constitutional rights, you know how to use these very same rights, but today you're choosing not to use those rights in exchange for a plea bargain agreement. So, for example, do you know what a jury trial is?
No, I don't.
A jury trial is where you start the process. I am not guilty. And then that puts the state on notice. They got to bring some witnesses in to testify under oath. And a jury would listen to that testimony. And a jury has a couple of choices. They could believe none of it. If they don't believe any of that evidence, you're not guilty. Or they could believe some of it. But in the end, if they think there is enough evidence, either some of it or all of it, they then would decide, we think you're guilty because we've heard enough evidence to find you guilty beyond a reasonable doubt. You'd also get an opportunity, if you wanted to, while you have no burden, the state, after they're done presenting their case, your defense counsel could ask those same people questions. He doesn't have to. Or he could even bring in witnesses, even though he doesn't have to produce any evidence. Do you understand what a jury trial is?
Yes, sir, I do understand what a jury trial is. That was my mistake.
Any of these causes, would you like a jury trial?
No, sir.
Okay. Mr. Campbell, I think you understand the rights that you're waiving as evidenced by your questions to me about it, your answers to me, your signature on each of the lines, and your attorney's signature assuring the court that you two have talked. So I don't feel necessary to read all of this to you, and I'm not going to, but I would like to talk to you about two of the rights that you waived. You have an absolute right to remain silent. You waived it by pleading guilty to all of these announced causes. Likewise, Mr. Campbell, you have an absolute right not to give evidence against yourself. You waived it by signing all of those separate judicial confessions. No one can make you plead guilty or sign a judicial confession unless you decide to do it yourself. But if I believe it and accept it as evidence, that is enough evidence today at your trial on each of these matters to support a finding of guilt by me. You understand that?
Yes, sir.
So, will you waive your right? Will you waive your right to remain silent and consent to my questioning?
Sorry, guys. Totally, that was not on purpose. I accidentally moved my mouse to the corner of my screen, and apparently that makes the screensaver come on, which makes the video, everything go away. But I can do this. I got it. We're not going to panic. I'm going to do that. I'm going to play.
You swear or affirm the testimony you shall give will be the truth.
Yes, sir.
Yes.
Put your hand down, Mr. Campbell. Dirk Andrew Campbell, aka Dirk Andrew Campbell Sr., did you voluntarily plead guilty in each of these causes, and did you voluntarily sign each separate judicial confession only because you are guilty and for no other reason?
Yes, sir.
All right. Mr. Campbell, are you satisfied with Mr. Wilson's representation on each of these causes?
Yes, sir.
You don't got to write him a Christmas card. My point of inquiry is, did you talk to him or someone in his office about the cases? Did you have a conversation?
Yes, sir.
Okay. Mr. Wilson, do you feel comfortable expressing an opinion, if you have one, as your client's competent to stand trial for all of these matters?
I do, Judge. I believe Mr. Campbell is fully competent.
Thank you, Mr. Wilson. Mr. Baskett, in each of these causes, has the district attorney's office complied with the Michael Morton Act and that you made available to the defense the evidence in your possession?
Yes, Your Honor.
Thank you, Mr. Baskett. Mr. Wilson, are you satisfied that the state of Texas has complied with the Michael Morton Act?
I am.
Did you then discuss with your client the evidence that was made available to you?
I did.
Thank you, Mr. Wilson. Mr. Campbell, today is your trial for each of these stated causes. The state of Texas did an investigation, and when they were done with that investigation, they felt confident they had found enough evidence to prove you guilty beyond a reasonable doubt at your trial. They then turned it all over to your defense counsel. Did you have a conversation with your attorney about the evidence, the case that the state wants to try against you today?
Yes, sir.
Your risk at today's trial is as follows. On the second-degree felony in cause number 75606, you face 2 to 20 years. And if I accept the enhancements, which I have not asked you about yet, that's a 2 to 20 punishment range. It makes it a first degree 5 to 99. On the following two cases, which are state jails in cause numbers 879 and 890, you have a state jail felony accusation, which is 180 days to 2 years flat time with 2 enhancements. What is that punishment range, Mr. Wilson?
With the 2 enhancements, it's a third degree 2 to 10.
Good.
Which changes after the finding of guilt, changes the punishment range to 2 to 10 years and a fine not to exceed $10,000. And then you have, in the same order, 3 manufacture, delivery of a controlled substance, felony group 1. These are first degrees, 5 to 99 to life. And if I accept as true the felony enhancements, that changes the punishment range to a minimum of 15 to 99 to life. And finally, the last charge is a third degree felony possession of a controlled substance, penalty group 1/1-B, which is 2 to 10, with an enhancement paragraph changing that to a second degree 2 to 20, with a fine not to exceed $10,000. Here's what you're asking me to do today. You're asking me first, let me cover this. To each of the enhancement paragraphs, how do you plead true or not true?
True.
All right then. So with that, those pleas and that true, if I accept it, you're asking me to sentence you in cause number 75606-B, 30 years at the Texas Department of Criminal Justice Institutional Division, followed by 2 10-year sentences, and then 3 30-year sentences, and finally a 20-year sentence on that last case. And it appears in each court costs and court-appointed attorney's fees. Did I properly announce your agreement, Mr. Campbell?
Yes, sir.
Mr. Campbell, I am not obligated to follow any of these. However, if I choose not to follow them, I would let you withdraw your plea of guilty. It could not be used against you in the future. But if I do this today and give you what you have asked, and later you think, I didn't want to do that, my rights were violated, the judge made a mistake, Mr. Wilson
Have you
didn't do
seen a
something.
defendant
Whatever
that
your
could pay it?
allegation is,
'Cause I don't think I have.
unless you reduce it to writing today,
And
so I could try to fix it, so I can read it and fix it. Your odds of winning that complaint
Concurrent.
today, in the future on a notice of appeal or a writ, very, very slim. You understand that?
Yes, sir.
Anything about this conversation make you change your mind about your decision to plead guilty?
No, sir.
Dirk Andrew Campbell, aka Dirk Andrew Campbell Sr., I find that each of your pleas have been made knowingly, intelligently, and voluntarily. Further, I find evidence sufficient support finding of guilt in each cause, and I now do find guilty of having committed each of the announced causes. Likewise, I will accept as true all of the enhancement paragraphs that you pled true to. Mr. Baskett, is there anything at bar of sentence?
No, Your
Mr. Wilson, anything in bar?
Nothing in bar, Judge.
Dirk Andrew Campbell, aka Dirk Andrew Campbell Sr., having previously found you guilty in cause number 75606-B, I now sentence you to serve 30 years at the Texas Department of Criminal Justice Institutional Division. I will assess court costs, court-appointed attorney's fees. In cause numbers 75879-B and 75890-B, I will now sentence you to serve 10 years at the Texas Department of Criminal Justice
You said
Institutional
30?
Division. Likewise,
Oops.
assessing court costs and
Sorry.
court-appointed attorney's fees. In the following three cause numbers, 81318-B, 81319-B,
No.
and 81502-B, I
Uh,
sentence you to serve 30 years at the Texas Department of Criminal Justice
Yeah.
Institutional Division with the associated court costs, court-appointed attorney's fees. And finally, in cause number 31145-B-CR, I sentence you to serve 20 years at the Texas Department of Criminal Justice Institutional Division with court costs and court-appointed attorney's fees. Of course, all of these are to run concurrently at the same time.
What?
Mr. Andrew, my God, Mr. Campbell,
Yes, sir.
I did what you requested me to do in each of these causes. Would you like to file a notice of appeal complaining of a mistake or an error?
No, sir.
Would you like a new trial in any of these
It's got
causes?
30 years.
No, sir.
Yeah, it's concurrent. Of course.
What questions do you have for me?
I have none, Your Honor.
All right, Mr. Campbell, thank you. Mr. Baskett, any other matter before the court?
No, Your Honor.
Wilson, any other matter?
No, Your Honor.
There's one.
Mr. Campbell, I wish you the best of luck. Please
Uh-oh.
give a fingerprint to the deputy.
Transition.
One more thing.
There you go.
I have to assess court costs and court-appointed attorney's fees. I've got a lot of options here. Do you want me to check the box that says, do not remove court costs and court-appointed attorney's fees from my inmate trust account
Yeah,
with
thank
the promise that upon parole, you'll pay them back?
Yes, sir. Please do.
Ms. Morris, would you please make that happen? All right, then. Good luck. Court's adjourned.
Thank you, sir.
Okay, that's one thing I don't hear a lot of judges ask is about removing the court costs and fines from their inmate accounts, which basically means like they'd never be able to get commissary. I think. Like, have you guys ever heard anyone else ask? Because I feel like the only person I've ever heard ask is Judge Weaver, and I feel like he asks pretty often, especially when he sentences somebody to like a significant amount of time. Okay, so I'm also transferring to the rest of the clip because we have to come back to the first guy that misunderstood what a jury trial was and thought maybe he wanted one. Here we go. Oh no. Oh no. Oh no. What did I do? Oh my gosh, guys. I'm so sorry. Hold on. What? Oh no. Okay, totally messing this up. Hold on. I am trying to, thank you, Lisa. I am trying to get the file from my computer to Chrome to play on here, but it's like not going into the, Okay, and I've got so much, it's really hard to find. Okay, where's the by judge? Judge Weaver, right here. And he is in Potter County. Thank you, Monica. Okay, change it to, oh shoot. Okay. Okay. Wait. Okay, this is what I'm going to do. While I'm figuring that out, I am going to switch to something that actually Monica, well, yeah. I saw Monica in this room today, and I had it going, and I was recording it, and I was kind of watching, kind of not watching, and I thought maybe I could watch a little bit of it or something in case something went wrong. And good thing I had a backup because it totally did. I do IT support for web app. Chrome is some Oh, Jessica, you have no idea how much IT support I need. So this one, what do you guys think? How many of you saw Judge Weaver today? I mean, Judge Webster today. I feel like probably most everybody. What do you think? Monica, OMG, this is great. So that's one vote for playing. I guess we're going to play because the other option is just to sit here and watch me panic trying to figure out the last 2 minutes of the other court case where the guy couldn't stop laughing. But Webster, oh, wait, this is not Judge Webster. I'm sorry. This is Judge Webster's area. I always kind of refer to everything like it's in this little Kansas, because she's Kansas, right? I haven't actually watched a lot of Judge Webster because I would always see her on other channels, and I never wanted to, if I knew like I was going to watch it somewhere else later, it's like I wouldn't want to double watch it and watch it during the day when I could be like watching someone else. This is Kansas. This is where they have the Sallyport. Remember there's Sallyport. This is not Texas Judge Webster. This is Kansas Judge Webster with like, she always has like her cool little glasses. Judge Serious. Yeah. So anyway, Monica says it's great. Lady Webster. Yes, Lady Webster. But this is not Lady Webster. This is just Lady Webster's Kansas. Because I feel like I kind of view her as like the queen of her realm, which includes this jurisdiction, right? Like she has the Sallyport. There's a whole bunch of other judges there, but it all belongs to Queen Webster. Am I wrong? I don't think so. I mean, possibly. Okay, so here we go. I can go over here and I can make my face go away. Please go away, face. Okay. And all right, let's go. I haven't seen it. Yeah, I saw you and Cha in there and you guys saw it. And I was like, okay, well, maybe I will save this one. Because I totally was not paying attention. All right, here we go. Maybe. Play. Oh, wait. Why is it all the way at the end? God, that scared me to death. Breathe. Why is it going all the way to the end? Oh my God. Hold on, guys. I thought it was going to be so easy. It's right here. Wait, where did it go? I moved it to here. Oh, I moved it. PHC docket. I guess you can't move it after you put it into Chrome, right? Probably. Yeah. I put it in Chrome and then I moved it. Okay, so enter. I got this, guys. I got it. And okay. Share. PHC.
It's
Kingdom
case
of
number
Lady Webster.
2023 CR 126. Mr. Schartz appears apparently from a correctional
Okay.
institution.
Okay. Is his name Mr. Schartz? Okay, Jessica, good to know that Chrome had 3 updates in the last 3 weeks because I have updated it never in the past, I don't know, ever. But this poor guy's name is Mr. Schartz. I bet he had a rough time in middle school.
By Zoom. James Watts is defense counsel. Brett Sweeney on behalf of the state. What announcement is made regarding preliminary hearing right in this case, Mr. Watts?
Well, Your Honor, I've not had a chance to speak with Mr. Schartz about this case because obviously he is at a correctional institution. My suspicion, however, dealing with Mr. Schartz is he wishes to set this case for preliminary hearing. Is that correct?
Yeah, that's correct.
This is on a forgery matter, correct? Alleged forgery?
Yes.
You guys know the attorney Sackrider from, God, what is he in? The CTAC? Is he CTAC? I don't know. I've seen several Sackriders. I didn't even know that was a name in real life.
Watts, are you aware of any weeks in August or September that you're
Jessica.
not scheduled for jury trial?
Oh, yeah.
I'm sorry, Your Honor.
Are you aware of any weeks in August or September where you're not scheduled for a jury trial?
Should I speed this a little bit?
Well, August 6th, starting on August 8th is scheduled. August 1 is scheduled. August 15 is
Yeah,
scheduled.
scheduling.
They are all set for, take that back. No, they're all set for jury trials in August. Again, they may not well go, but right now there's several set on each day.
All right. Looking at Friday, September the 8th at 11 a.m.
Right now, Your Honor, that should work.
Should work for the state, Your Honor.
Court will set the Schartz preliminary hearing for Friday, September 8th, 11 o'clock a.m. Defendant must fully participate by Zoom audio visual at that time. Again, Friday, September 8th, 11 o'clock. Anything else we need to address currently, Mr. Watts?
Not at this time, Your Honor. Thank you.
Mr. Sweeney?
No, Your Honor.
Very well. Thanks to the correctional institution with their assistance with Mr. Schartz here this afternoon. There's nothing further. The Schartz matter will be in recess. We'll move on to another matter.
Schartz matter.
Thank you.
Schartz matter. Yeah, I'm a child too, Lisa.
We've got someone in your office, Mr. Watts. Can we go ahead and address that one?
I do, Your Honor. That is Mr. I have the file in front of me a moment ago. Here it is, Mr. Perez. I also have Ms. Baker, Ms. Mattingly here in the office as well.
This is State of Kansas versus Rubio, Luna Perez. Case number 2023 CR 108. Defendant appears in the office of his attorney, James Watts. Brett Sweeney appears for the state of Kansas. What announcement is made here, Mr. Watts?
Your Honor, it's my understanding after speaking with my client, he would waive his preliminary hearing.
Very well. All right, Mr. Perez, your attorney has announced that you now intend to waive your preliminary hearing. Do you understand that a preliminary hearing is a proceeding to determine if there's probable cause that a felony crime has been committed and that you committed it?
Yes, I understand.
You understand that if you waive
Yeah.
preliminary hearing, the court will bind you over for trial at this point without any further determination of probable cause?
Yeah, I understand.
Do you understand that once you waive your right to a preliminary hearing, you cannot get that right back, though you may proceed to trial later?
Yeah, yes,
Have you had an opportunity to consult with your attorney about this?
yeah. we've been
And do you
talking.
now freely and voluntarily waive your right to a preliminary hearing in this case?
Yes, Your Honor.
Mr. Sweeney, does the state waive its right to a preliminary hearing?
Yes, Your Honor.
Court finds that both parties have waived their rights to a preliminary hearing. Defendant Perez is bound over on the felony charges of the information. We'll also note there's one or more misdemeanors also pending in the case. It's the likelihood here that there might be some agreed upon resolution down the line, Mr. Watts.
Your Honor, I think there's a high likelihood of that.
Watts, are you available for arraignment Monday, August 14 at 10 o'clock in the morning.
Your Honor, actually in front of Judge Crum that time, as well as 9 and 11 that same day. I'm in front of you at 11.
I see that.
Yeah.
Friday, August 18, Mr. Watts,
The
11 o'clock.
the morning is pretty open. 11 should be fine, Your Honor.
All right. I will set the Perez arraignment for Friday, August 18 at 11.
Judge, I had set something there as well. 10 o'clock is open.
Dream.
Counsel, will that work?
Yes, sir.
Sorry.
That should work, Your Honor.
Wait.
All right, then I'll set the Perez
Yeah.
arraignment at 10
Sorry,
o'clock a.m.
guys.
Friday, August 18.
Uh,
Perez must fully participate by Zoom audio-visual communication at that time. Mr. Perez, I highly suggest that you do it from the office of your attorney, like you were doing today.
Yeah, I'll make sure.
Okay, August 18,
should
10
I
o'clock
skip
in
to
the morning.
something,
for arraignment.
Monica? Because I
Anything
haven't
else we
seen
need
this
to
at
address
all.
currently, Mr. Sweeney?
No, Your Honor.
Mr. Watts?
No, sir. Thank you.
All right, very well. Then the Perez matter will currently be in recess.
Oh my gosh, this is really hard for me to Schartz right here. Okay, 7:44.
She is right here in the office, Your Honor. We can take that case up as well.
It's
Okay.
the state of Kansas versus Ashley Suzanne Mattingly, case number 2023 CR 240. Brett Sweeney appearing for the state, James Watts as defense counsel, defendant Mattingly appearing in her attorney's office by Zoom. What announcement is made regarding preliminary hearing right in this case?
Your Honor, I believe this case is also for waiver of preliminary hearing. I want to consult briefly with Ms. Mattingly. It's been a few days since I spoke
You
with her
guys are
last.
children.
May I have a
Okay,
moment?
Monica, I will skip
Just a
forward.
moment, Mr. Watts.
To where?
I'm trying to determine why this case is here.
Past this chick. Okay. Oh, there we go. Now we got the Sally port. Is that
A
where we wanna
felony
be?
case.
Oh, no.
I've now located what appears to be the primary reason this
This is
setting was made.
hard to watch
20
court that you haven't seen before. Because I don't like to not know where I am. I'm not. Wait.
This case was filed as a
I'm
misdemeanor
there,
case.
Or I'm not. Maybe Jessica's dead.
Is there an amended charging document here, Mr. Sweeney?
There is not, Your Honor. I know she has several other cases, and I think she does have several other felonies that are set here. So my guess is that when first appearance happened back in May, that the court, for one reason or another, had, I don't know if the court likes the term, but tag along with the other felonies.
I don't like the term, frankly, but I understand the concept, Mr. Sweeney. I have now located what appears to be the primary reason this setting was made. 2023 CR 239, which is a felony case. And that's a possession of methamphetamine, a level 5 drug felony case. So there would be the issue of preliminary hearing waiver as to that matter, obviously not the misdemeanor. Mr. Watts, if you come back on. Mr. Watts? Lost you there for a moment, counsel.
Now, Your Honor, if I could speak to my client a little while, for a few moments longer.
Well, I'll go ahead and move on to some other cases then.
Okay.
All right. A probable cause?
Yes, Your Honor.
You understand that once you waive your right to
I'm going where Monica's telling me to go. Monica, I messaged you on Discord because there's like a 20-second
Okay, I need you
delay
to
when you
speak up.
type into YouTube.
the charging document to be
On
read to him.
Discord. Moment.
We'll waive formal reading,
Past
Your Honor.
this guy
What
in
plea
the
is in?
back?
Not guilty, Your Honor.
Court will accept the plea of not guilty to all charges of the information. Will establish appropriate jury trial and pretrial conference settings.
Monica is running past
The defense-
this.
Okay, I didn't really hear him.
Here.
Your Honor, my client has an.
Past this.
Thank you.
Have a good fourth.
You too.
Thank you.
Okay, this one's over. So let's see who's after this guy.
Mr. Watts,
Zach Ryder
Yes, sir.
clip. I don't have a Zach Ryder clip.
I
don't
trust
know.
you're ready to go
I'm
on
sure I
that.
do. I just don't know where.
Yes, sir.
okay, again, there's two Mattingly matters, 2023 CR 239 and
Mattingly?
240. Mr. Sweeney, Mr. Watts, and Ms. Mattingly appearing as before. What announcement do you make now, Mr. Watts?
Your Honor, it's my understanding my client would waive her preliminary hearing on 22 CR 239.
You're also appointed on 240. What's the current status of that?
Well, Judge, it looks like, and I don't have any notes in my file, so this is the first court date I've had on it. It is a misdemeanor matter and it arises out of a search warrant.
This is a disaster. Here
Other
we
matters
go.
on the docket.
Forward, forward, forward.
CR 479. James Watts appears as defense counsel. Brett
Okay.
Sweeney on behalf of the state of Kansas.
Got this guy at the Sally Port.
What announcement is made regarding preliminary hearing right?
Your Honor, I had a discussion with Mr. Chairs approximately a week ago. After that discussion, it was my understanding he wished to waive his preliminary hearing.
Is that right, Mr. Chair?
Is that still your position, Mr. Chairs?
Waive it.
Is that still your position, Mr. Chairs?
No, we talked about that, but I wasn't certain because I didn't understand. I thought maybe we can postpone it until I can figure out, maybe find out for sure what I'm doing, because I had a bottle of testosterone. I could have gotten mixed up with something else, you know. I said, I don't know nothing about that. But no, I don't know nothing about that kind of stuff. I
All right,
just
Mr.
learned.
Watts, if your client's not in a position to waive preliminary hearing at this time, the court's going to set one.
Yes, sir.
I thought we talked about this just the other day. We were talking about
We did, Mr. Chairs, and I have in my notes that you intended to waive. If that's not your position, then the court's going to set a preliminary hearing.
I thought we was gonna postpone it until.
Mr. Watts, I'm looking at Monday, August 28 at 11.
August 28 at 11 a.m.
Yes.
I'm in front of Your Honor.
What did you say, sir?
Maybe find out.
Chairs, approximately a week ago. After that discussion, it was my understanding.
Sorry. I want to hear what this guy said again because I am also confused.
All right, this is Mr. Chairs. Yes, sir.
He said something about
Jeffrey L. Chairs.
Yes, sir. How
His
you
name
doing?
is Chairs.
All right.
Schartz
We'll
and
go ahead and call your
Chairs.
case, Mr. Chairs. It's the
Nice.
state of Kansas versus Jeffrey L. Chairs, case number 2022, CR 479. James Watts appears as defense counsel. Brett Sweeney on behalf of the state of Kansas. What announcement is made regarding preliminary hearing right?
Your Honor, I had a discussion with Mr. Chairs approximately a week ago. After that discussion, it was my understanding he wished to waive his preliminary hearing.
Is that right, Mr. Chairs?
Is that still your position, Mr. Chairs?
Waive it.
Is that still your position, Mr. Chairs?
No, we talked about that, but I wasn't certain because I didn't understand. I thought maybe we can postpone it until I can figure out, maybe find out for sure what I'm doing, because I had a bottle of testosterone. I could have gotten mixed up with something else, you know.
Wait.
I said, I don't know nothing about with that. But no, I don't know nothing about that kind of stuff. I
All right,
just
Mr.
learned.
Watts, if your client's not in a position to waive preliminary hearing at this time, the court's going to set one.
Yes, sir.
How?
I thought we talked about this just the other day. We was talking about
We did, Mr. Chairs, and I have in my notes that you intended to waive. If that's not your position, then the court's going to set a preliminary hearing.
I thought we was gonna postpone it until.
Mr. Watts, I'm looking at Monday, August 28 at 11.
August 28 at 11 a.m.
Yes.
I'm in front of Your Honor at 10. That probably should work.
Okay.
You just like
I will set
accidentally
the Jeffrey
mix
Chairs
it up with
evidence for
heroin
preliminary
or
hearing
something?
for Monday, August 28 at 11 o'clock a.m. All right, Mr. Chairs, I'm going to order you as a condition of your bond to either appear at the Sally Port where you are today, or you can go to your attorney's office and participate in that hearing from there. One of those two locations, nowhere else, okay?
I'm not. I thought we was gonna postpone it to find out.
I'm not
Dude, it's
postponing.
happening. It's
'Cause
happening.
I need some time to find out what I'm thinking I might need me an attorney, to hire me an attorney. Cause I don't know I'm not getting no understanding on what we're gonna be doing and what
Well,
my options.
Maybe you need to confer further with Mr. Watts. I'm setting this off about
I stay
7 weeks.
in Wichita, sir, and I don't know. I don't know what I never really got a chance to really talk to Mr. Watts, really. Sat back and really
That's why I'm
talked to him.
setting this off 7 weeks, Mr. Chairs. That should give you an adequate opportunity to talk with him, hire your own lawyer, do whatever it is that you want to do. But I'm going to set this for evidentiary preliminary hearing to keep this case moving on Monday, August the 28th at 11. Okay? And I need you either at the Sally Port again or in your attorney's office.
Okay.
Okay? And it will be a Zoom evidentiary hearing.
So
Okay, Mr. Sweeney, anything else we need to address regarding Jeffrey Chairs?
Accidentally.
This time?
Who is my attorney?
James Watts.
This guy.
Okay.
Mr. Chairs, we spoke on the 28th for a little over half an hour at that time. Do you remember that conversation?
Yes, we did.
Okay.
Mhm.
And I
Then
thought
you
we
need
had-
to confer some more, Mr. Chairs, which I highly encourage you to do
Yeah.
as soon as you can, okay?
Excuse me,
Sure you
sir?
got Mr. Watts' phone number, right?
Yes, I do.
Okay.
I wasn't sure what you said, sir.
Mr.
got
Copel, can you write down that court date and time if you haven't already for him?
I got it all here for him.
Fantastic. I appreciate your assistance in that regard. Monday, August 28, 11 o'clock a.m. for evidentiary preliminary hearing with him either at the Sally Port or at his attorney's office. If there's nothing further, the Jeffrey Chairs matter will currently be in recess. We'll move on to another matter.
I mean, he got testosterone mixed up with what? Like, he has testosterone. And he.
Okay, Mr. Watts, you've got someone
It's
else
not a def-
who's participating on their own Zoom.
It's not a defense because if you have it, other drugs that you
Yeah,
accidentally mixed
Yes,
up
Your Honor,
thinking it was
Ms. Baker.
testosterone.
Lindsay Baker.
Yes, Your Honor.
Okay, this is State of Kansas versus Lindsay Denay Baker. It's case number 2023 CR 73. Ms. Baker appears on her own Zoom separately from her lawyer, James Watts. Brett Sweeney appears for the State of Kansas. What announcement is made regarding preliminary hearing right in the Baker case?
Your Honor, I actually had a email conversation with Mr. Sweeney shortly before this hearing about the resolution of this case. And
I
it
like
sounds
her
like that
shirt.
resolution may well be possible to plead to counts 2 through 4
that
of the information,
airbrush?
dismiss count 1, 2 through 4 being misdemeanors. And we of course will not, because one of the priors is a DUI, we will not be able to do sentencing today. I frankly not have a chance to get back with Ms. Baker as to their answer on that possibility, but I suspect, speaking with Ms. Baker, that that's something that she may well want to consider. We may be able to resolve this matter today.
Okay, I think you're going to
Seen
need
a
a
lot of
breakout
blue
session with
eyes
her though
today.
before we go any further. Do you represent
Breakout session.
Jason Hart?
I do not, Your Honor. I don't have that
Okay.
file in front of me. That may be Joe's case or someone else.
All right. I will address Hart while you talk to Ms. Baker. All right. I don't know why I'm getting feedback here, but
Oh, Mr.
Mandy, if you
Hart.
could put Mr. Watts
Looks
and Lindsay
familiar.
Baker in a breakout room.
Okay.
Jason Miles Hart.
Yes, Your Honor.
All right. It looks like that you've got two cases currently before this court.
Yes.
State versus Hart, 23 CR 20. State versus Jason Miles Hart, 23 CR 16. Brett Sweeney appears for the state. Mr. Hart appears apparently still representing himself. I see that you were trying to retain counsel on some previous appearances, but you don't have that done, Mr. Hart?
I have actually locked somebody in. I am meeting with a Leslie Holnick at the 10th at 9 a.m. and he will officially be my lawyer as of then.
I see that, Lisa.
There's been multiple settings and you just keep showing up and wanting your case moved off because you don't have an attorney yet. I mean, you say you're going to get one, but he never shows up with you.
I will have one as of the 10th this month.
That's what he said last time, probably. Having not seen it, I'm pretty confident.
State, have any comment?
No, Your Honor, I don't know that there's a lot that I could say that's going to change the course of what we're going to do here today. I do want the court to know that he has 2 other felonies that are not in this court, but are in, looks like Judge Hart's court. And he
Who
doesn't.
represents him over there?
No one. He's pro se in those 2 cases as well. He's got an August date.
Yeah, I've been trying to find a lawyer to deal with all of this. It's all from the same 2 incidences over a year ago, but I moved out of state about 9 months before the state presented any charges. So it's been a bit difficult, and I've had 2 family member deaths in the last 2 months. So I do have counsel that I will have as of the 10th. It's just been very slow going for me, and I apologize, Your Honor.
It's going to be the last continuance for this purpose, Mr. Hart.
Okay.
So you need to get that attorney on board and have that attorney enter their appearance in these various cases so that we know you have an attorney of record. I'll reset this to the 2:30 docket on Monday, July 31. Monday, July 31, 2:30, defendant must participate by Zoom. And Mr. Hart, if you get an attorney on board, I highly suggest that your next appearance be in that attorney's office by Zoom.
It will be.
And Your Honor, I'm actually going to be out of state on July 31. Is there potentially another day we could look at?
Well, somebody's going to have to cover that docket, Mr. Sweeney, for your office. Can't they step in and whoever's going to handle the rest of that docket that day? That's not a special setting. That's my next Monday, 2:30 docket.
Okay. In that case, it should be workable then, Your Honor. Thank you.
We probably we're going to do, as long as they can schedule for you down the line, that's probably the most important thing.
Sure. Thank you, Your Honor.
All right, Monday, July 31st at 2:30. You must fully participate by Zoom audio visual communication at that time, Mr. Hart, and I will expect that you'll have a defense attorney on board and with you at that next setting.
I will, Your Honor.
All right.
Thank you.
July 31, 2:30. There's nothing further. The Hart cases will currently be in recess. You can leave the meeting if you want to, Mr. Hart.
Plenty of time to
Yeah,
commit
thank you, Your Honor.
crimes, but just not enough time to hire a lawyer in between said crimes. I mean, get your
Doesn't
priorities together.
Look like we're ready for Mr. Watson, Ms. Baker yet?
Let's find Miss Baker.
They're still in the breakout room.
Mm-mm. Come back, Miss Baker. Brett Sweeney. I like Brett Sweeney. He was in one of my very first videos.
Hearing us before.
Okay, here we go. All right. Last one. Almost made it. Only like
Following a brief
6 or
pause in
7
proceedings,
technical
we'll
difficulties
resume
today.
with State of Kansas versus Lindsay, Denay Baker.
Getting better.
23 CR 73. Mr. Sweeney, Mr. Watts, Ms. Baker appearing as before. What announcement is made now, Mr. Watts?
Your Honor, pursuant to discussions with the state, it's my understanding that we will be entering a guilty plea to counts 2, 3, and 4 of the information. The state would in turn dismiss count 1. Sentencing will not be today because count 3 is a DUI, and I've directed Ms. Baker, she'll have to go get a drug and alcohol evaluation before we can do that sentencing.
All right. Is that consistent with your understanding, Mr. Sweeney?
It is, Your Honor.
All right. Ms. Baker, it's court's understanding then return for the state's dismissal of the felony count in count 1. You would be entering pleas to count 2. Possession of clonazepam, a class A non-person misdemeanor, count 3. Driving under the influence, a class A non-person misdemeanor, and count 4, possession of paraphernalia for use, a class B misdemeanor. Is that indeed your intention?
Yes, Your Honor.
Okay.
Yes.
Do you understand that class A misdemeanors are punishable by up to a $2,500 fine and up to 1 year in the county jail?
Yes, sir.
And that driving under the influence, a class A misdemeanor, has its own sentencing provisions, but could be punished by up to 12 months in the county jail and up to a $2,500 fine. You understand that?
Yes, Your Honor.
Possession of paraphernalia for use obviously would also be punishable by up to 6 months in the county jail and up to a $1,000 fine or both. Do you understand that?
Yes, Your Honor.
Okay. Are you entering a plea of guilty to these 3 charges at this time?
Yes, I am, Your Honor.
According to the state's charging document, this all took place on August 25 of 2022. Is that when it happened?
Yes, sir.
It took place somewhere in Butler County, Kansas. Where was it?
McDonald's parking lot
In
in
what
El
city?
Dorado.
Okay, and that's in Butler
El
County, obviously. And you are in possession of clonazepam, a class A non-person misdemeanor charge, and you are in possession of that particular controlled substance at that time?
Yes, I was, Your Honor.
I remember to unmute myself. I'm kind of the same. I'm with you on that, Jessica, because like in my mind, a DUI is like life ending, career ending, like it's bad. It's a bad, bad thing. But I've seen so many today. I've seen people with I mean, what was that guy earlier? He had like 16. Not on my stream. It was on, I saw it when it was actually happening in court. I think Kitch may have done it, but I mean, when you're having like your 9th DUI and you're like, you've just like violated your parole because you're out. I mean, you have a DUI pending and you get another one and then you still get a bond set. It's just, I don't know. It really makes me upset.
Where was it?
It was in my purse.
And you knew it was in there?
Yes, I did.
All right. They also allege in count 3 that at that time you were driving under the influence, apparently charged as under the influence of alcohol. Do you acknowledge to the court that you were driving on that date?
Yes, sir, I do.
And that you were under the influence of alcohol at that time?
It wasn't alcohol. It was medication, clonazepam.
Okay.
Yes.
So you were under the influence of this drug to a degree that rendered you incapable of safely driving a vehicle?
Yes, sir.
You were also in possession of drug paraphernalia at that time? Ms. Baker?
Yes, yes, sir. Yes,
According
sir.
to the state's charging document, you were using your
I feel like everybody does know, but for anybody that doesn't, clonazepam, anything that ends in Pam, I believe, is kind of like a Xanax type of drug, like a benzodiazepine. So that's going to take whatever kind of alcohol or marijuana or whatever you have in your system and like multiply the sedation by like 10 or 20, I think. I mean, obviously I'm not like a pharmacy expert, but that's bad. You do not want to drive on that stuff.
your purse to store, contain, or conceal a controlled substance. Is that what you were doing?
Yes, Your Honor.
All right. So do you now freely, knowingly, and voluntarily enter pleas of guilty and accept conviction for counts 2, 3, and 4 of your charging document?
Yes, Your Honor, I do.
All right. Court finds that
Yes,
this is a
Your
free and
Honor.
voluntary. Okay. Anything else you want to say, Ms. Baker,
Sorry.
before I go further?
No, sir, I'm sorry. No.
Seems to be a
sorry.
little bit of a delay between when I speak and when she responds. All right. Court finds that this is a free and voluntary act on the defendant's part. She's been made aware of the possible penalties and that there is a factual basis for each charge. Court finds the defendant guilty pursuant to acceptance of her guilty pleas to count 2, possession of clonazepam, a Class A non-person misdemeanor, count 3, driving under the influence, a Class A non-person misdemeanor, and count 4, possession of paraphernalia for use, the Class B non-person misdemeanor. Because of the conviction in count 3, the court orders the defendant to undergo an approved alcohol and drug evaluation, a pre-sentence evaluation in the case, and the court will allow sufficient time for that to be scheduled, completed. We'll set a sentencing date out far enough to allow that to be completed and the report disseminated. Has any arrangements been made for the evaluation yet, Mr. Watts?
Not that I'm aware of, Your Honor. I informed Ms. Baker that immediately upon the close of this hearing, she needs to start making phone calls to get those arrangements made and get that evaluation set. And I know that the statute requires a specific drug and alcohol evaluation for DUI purposes.
I feel like I thought it was longer acting. The reason I know is because my roommate in college took it. It like lasted a long time, like longer than Xanax.
Mr. Watts, if you would look at your calendar for Monday, August 28th.
She was, okay, let me just pause that.
Yes, sir.
Oh, wait, no.
I think we
Are
just,
you available at 1:15?
We should be, Your Honor. I think we just set something at 11 that date. Is that right?
Yes, chairs is set at 11.
Yes, sir. 1:15 should work.
All right. Speaker, I'm going to set your sentencing proceeding for Monday, August the 28th at 1:15 p.m. Where are you participating from today, Ms. Baker?
I am at my residence in Leon.
Okay, I'm going to order you to appear at the Sallyport location at the Butler County Judicial Center for your
Oh,
sentencing on
Sallyport.
Monday, August the 28th. It's on the south end of the Judicial
sir.
Center. You may have appeared there before. That's where you are ordered to
Yes.
appear
Like the
for
one I
your
bet, she
sentencing.
gets probation.
And Mr. Watts is correct. It may take some time to get scheduled and get this evaluation completed. We need to have it completed and that report available for your sentencing on Monday, August 28th at 1:15 p.m. Again, with you ordered to appear at the Sallyport location at the Judicial Center. With that order made, I'll continue Ms. Baker under her current bond. All right, so we've got our sentencing date
You are
set and
not.
evaluation ordered. Is there anything else we need
Okay.
to address from the state's perspective at this
This is
time, Mr. Sweeney?
probably
No,
it,
Your Honor.
right?
Mr. Watts, anything further?
Yeah.
No, Your Honor. Thank you.
Record should reflect that the court does.
Okay. Oh, okay. So I'll go ahead and end, I guess, with a little story about the reason why I know what Klonopin is. And I had a roommate in college, and she was a sweetheart. But she had anxiety and some other things. I don't know. But have you guys ever seen the movie Girl Interrupted? I'm waiting for to hear you guys respond, but obviously, okay. So it's the movie where Angelina Jolie's in a mental institution, and anyway, it's a really good movie. It was a really good movie, but she, I don't know, got it into her head that she wanted to be in a that's where she wanted to be. She wanted to be in a mental go to a mental hospital or something because it looked fun. I guess. I don't know. But so she checked herself in, and then it was not like the movie, at all. And she couldn't get herself out. And I remember just, oh God, sorry, Monica, I didn't mean to leave that up. Yeah, Girl Interrupted. But like I said, she had some anxiety and stuff, but she went to the mental hospital, and then she couldn't get out. It was just like a regular hospital. It was a floor in a hospital. And we went to visit her, and it was definitely not at all like the movie. Her dad had to come down from Maryland or somewhere way up north, and we were way down south. But she did eventually get out. But she had Klonopin and Xanax. And I just remember that Xanax was for if she was having a panic attack and needed something to calm her down immediately. And Klonopin was something if she was having a hard time, she would need to take it, and it would take a little bit longer to start working, but it would last for a really long time. So if my other roommate borrowed a Klonopin instead of a Xanax, then she would sleep for a day and a half. Anyway, whatever, not important, but it was a better story if you were there. But thank you all for coming. I really appreciate you being here for these practice streams. I really when I'm just figuring out how to do things, there's always several technological issues. The very first case where the guy was laughing, the part that I couldn't pull up was when they brought him back in at the end, and basically what happened is that he took back what he said about wanting a jury trial. He re-talked to his attorney, and everything just turned out as normal. It was a trespassing, which seems to happen a lot in Potter County, but it was just a trespassing. I'm pretty sure he got out with time served, but it was a very uneventful 2-minute interaction between the two. So again, thank you for being here and letting me practice doing this. I have a lot more stuff, and I'm kind of saving the good stuff until hopefully I get better at doing this. So I've got a lot of good stuff to come. Thank you for being here, and I don't know when next time will be, but I'll see you then.